Hello, people that are on the program already. This is Kristen O'Neill. I think we'll probably have some people signing on as I speak. I'm going to get the PowerPoint up and going, and we'll start at 10 o'clock. Thank you. Good morning again. This is Kristen O'Neill. Got some more people logging on. We will wait until 10 a.m. to get started in case people are logging on the last moment. And PowerPoint is up. If you have questions as we go along, you are welcome to enter them into the chat feature. Just so people are aware, I can't really provide tech support. I'm sort of a one-woman show, so if you're having tech issues, there's really not anything I'm going to be able to help you with. I mean, certainly if everybody's having a problem where they can't hear me or something like that, I would want to know. So if you can't hear me, let me know. But if it's just something on your end, that's not something I'm going to be able to assist with. A few more minutes here. Thank you. Okay, good morning. This is Kristen O'Neill. I am the Assistant Director of the New York State Committee on Open Government. And this morning we are doing this is a virtual information session regarding the Freedom of Information Law. It's really geared towards everyone. It's, I think, helpful for the general public, but also for people that work directly with the Freedom of Information Law, that are maybe Service Records Access Officer or involved in responding to Freedom of Information Law requests. If you have questions as we go along, you're welcome to enter them into the chat feature. If the question has already been addressed during the program, I may skip over it because sometimes people have a tendency to ask questions before we've gotten to that portion of the program. The program is being recorded and will be posted on the Committee on Open Government's website. If you go to this is my contact information. If you have a question for me specifically, maybe something I've said during the program, you're welcome to email me directly. At the end of the PowerPoint, you're going to see an email that is something you can use when you have a question for any of the attorneys in our office. So if you have a question about the Freedom of Information Law or the Open Meetings Law generally, I would encourage you to use that email address or call this telephone number and ask to speak to any of the attorneys in the office, because if you're willing to speak to anyone and any of the attorneys are perfectly capable of responding to your inquiries, you're going to get a response more quickly than if you're waiting for just me to get back to you. So that email address will be at the end of the program. Our website, as you can see, is www.opengovernment.ny.gov. If you go to that page and scroll down a bit, you're going to see a section on the home page that links you to training, recordings, and material. So hopefully by the end of this week, I will have copies, recordings of this program available and posted on our website. In addition, there are older versions of both the Freedom of Information Law and the Open Meetings Law presentations that are already posted on our website. These slides are also available on our website. So that's another question that people often ask frequently. Can you send me a copy of these slides? I won't be sending out slides individually. I just ask that people go to our website and pull them up from the website. New York State Freedom of Information Law is codified in Public Officers Law, Article 6, Sections 84 through 90. The best way to find a copy of the Freedom of Information Law is to go right to the Committee on Open Government's website. We always keep an up-to-date version of the statute posted on our website. So that's the easiest way to find it instead of trying to dig it up through other legal research. Here is sort of an image of what our Committee on Open Government's website looks like. This is a little bit dated, but it's essentially what our website looks like. You'll see that this sort of turquoise blue-green bar, there are menu headings. For example, if you click on Freedom of Information Law, there's going to be a drop-down box. There's going to be a copy of the statute, a copy of our regulations, a copy of a link to our advisory opinions that are indexed alphabetically by key phrase, and links to our case law summaries. The same is true of the Open Meetings Law. In addition to what you see here, we also have added a link for meeting recordings, the meetings of the actual Committee on Open Government, and information about those meetings is also on our website. We have a news section, so if there's anything any updates, recent updates to the Open Meetings Law, the Freedom of Information Law, you can find that information there. And of course, we have a contact us page that has our phone number and email address. So by way of background, the New York State Freedom of Information Law was enacted in 1974, but it was fairly limited in scope. There was access to 9 categories of records. And if the record that you were seeking was not included in those 9 categories of records, you were essentially out of luck. It was not something that you would be entitled to under the Freedom of Information Law. Nobody was particularly thrilled with that version of the statute. And so in 1978, the original version was repealed and replaced with what is essentially the current version of the law, or the general premise is that the Freedom of Information law is based on a presumption of access. So when you want to make a Freedom of Information law request, or if you're a government agency receiving a Freedom of Information law request, you should always start with the assumption that all government records are subject to FOIL disclosure. And then you can review the records to determine whether the records or any portion of the records fit into one of the permissible grounds for denial. We very frequently get questions about whether a particular record is a public record or whether a particular record is foilable. You should always start with the assumption that all records are foilable. You have, as a member of the public, have the right to request any record you like. And that's not to say you're going to be able to obtain every government record that you would like, but you have the right to request under the Freedom of Information law any type of record. And as a government agency, you should always have your mindset is that a record is going to be available under FOIL unless you can assert one of the permissible statutory grounds for denial. Who is covered by the Freedom of Information law? Who is required to comply with the Freedom of Information law? FOIL governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. So essentially you start at somewhat maybe at the highest level of executive government, and that would be you've got the governor's office and all of the state agencies that work that are under the executive agency. For example, I work for the Department of State. That is an agency subject to FOIL. The Department of Health, Department of Labor, the Office of State Comptroller, the Office of the Attorney General. All of these statewide government agencies are agencies subject to FOIL. In addition, you have county level government. Counties and all of the government entity departments within a county government are subject to FOIL. Cities, towns, villages, school boards, fire districts. There are thousands of units of local government across the state of New York, many of which are subject to being subject to the Freedom of Information law and being obligated to comply with that statute. The courts, so you'll notice in the definition that judiciary and the state legislature are exempt from the definition of the term agency. The courts are not subject to FOIL. Courts are not required to respond to Freedom of Information law requests, and access to court records, records maintained by the courts is not governed by FOIL. It is governed by New York State judiciary law. So that's not to say that court records may not generally be available. It's just that the Freedom of Information law is not the statute that governs access. So if you have, for example, a town that has a town court or a village court or city court, whatever the case may be, you can't submit a Freedom of Information law request for those local court records, nor can you submit a Freedom of Information law request to any of the county Supreme Courts or appellate level Court of Appeals, for example, for those court records. Access is governed by another statute. Access to state legislature records is covered by the Freedom of Information law, but access is much more limited in nature. It's almost very similar to that original 1974 version of the statute, whereas there's a section of the Freedom of Information law that lists the categories of records that you can obtain from the state legislature. And if you don't see it on that list, again, you're going to be out of luck. So the state legislature is not an agency as that term is defined by the Freedom of Information law. I apologize, my voice is a little cracky. I've got a little bit of a cold, so if I stop at any point, it's probably because I just need a little water, or else I possibly even need to blow my nose, so I apologize. The Freedom of Information Law states that the governing body of a public corporation, or the head of an executive agency, or the governing body of other agencies shall be responsible for ensuring compliance with the Freedom of Information Law regulations. They're also required, our regulations, the Committee on Open Government's regulations, which have the force and effect of law, just like a statute, require that every government agency designate one or more persons as records access officer by name or by specific job title. That designation should include a business address and when requests are accepted via email, an email address. And the records access officer has the duty of coordinating the agency's response to public requests for access to records. They have their duty of coordinating the agency's response to FOIL requests. So you'll note that the agency as a whole has a legal obligation with regard to the Freedom of Information Law. The records access officer is not the only person who is legally responsible for complying with the Freedom of Information Law. It's just that they are the person that has been designated by the agency to coordinate the agency's response. The term record under FOIL is defined very broadly. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then it gives a list of examples, but it is incredibly broad. It could, of course, it means things like paper and video and audio and photographs. It's any information in any physical form whatsoever. It also includes data that can be extracted from a database, regardless of whether it's a report that's produced in the normal course of business. If you can extract data from a database, that is a record subject to the Freedom of Information Law. Under FOIL, an agency is not required to create records. They're not required, an agency is not required to answer questions. It's not required to provide information that does not exist in record form. This does not mean that an agency is not required to make copies of records or to convert the records to a preferred format if they have the ability to do so. There are 3 exceptions to the rule that an agency is not required to create a record. One exception is that every agency is required to maintain a record of how each member of a public body housed by the agency votes in any given proceeding. I always note that this seems odd that this requirement is contained in the Freedom of Information Law as opposed to the Open Meetings Law, but there it is. You would think it would be under the Open Meetings Law minutes obligation, but there is this provision of FOIL that requires that every agency maintain a record of how each member of its public body votes in any given action. The second exception is every agency is required to maintain and make available a list that includes the name, public office address, not home address, but public office address, title, and salary of all of its employees and officials. The third exception to the rule is that every agency is required to maintain and make available a reasonably detailed subject matter list. Often at the local level, for example, counties, cities, towns, villages, school districts, many municipalities and local government entities adopt the record retention and disposition schedule that is established by the New York State Archives as their subject matter list. They line up very nicely. So if you're looking for a subject matter list for a local municipality, Often the easiest thing to do is to look for the record retention and disposition schedule established by the New York State Archives. Another distinction about creating the difference between creating a new record and preparing a copy of a record. There's a provision in the statute in FOIL that requires that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. So here an example might be if someone submits Freedom of Information Law requests and wants the record in its original form. For example, it's an Excel file or an Access database, something that's editable. If you have the ability to provide it to them in that electronic format, you're required to do so as an agency. And if an applicant for records would prefer that you scan the records instead of making photocopies, and if the agency has the ability to scan just as easily as it would photocopy, then yes, it would be obligated to scan those records and provide them in an electronic format. Further, when an agency, I think I mentioned this earlier, when an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. Any programming necessary to retrieve the record and to transfer that record to the medium requested by a person shall not be deemed to be the preparation or creation of a new record. So again, if an agency has the ability to query a database and produce a record that contains the information sought, then there's an obligation to provide that record. When making a Freedom of Information Law request, an applicant has an obligation to reasonably describe the record sought. So part of that is fairly common sense in that if an agency receives a Freedom of Information Law request and can't quite figure out what's being asked for, then perhaps the person who's made the request has not reasonably described the record sought, and the records access officer would have an obligation to go back and request some sort of clarification. Another issue that has come up that's based on very old Court of Appeals case law is whether the agency has the ability to locate or retrieve the record with reasonable effort. And often the answer to that question will be different depending on whether the records are paper or electronic records. It is generally much easier to locate records when they're maintained electronically and are searchable electronically than it is to locate records that are only maintained in paper form. For example, when you file records, there's a certain filing system that you use. Up until the past couple of years, the Committee on Open Government receives copies of, were required by law since the beginning inception of the statute. Every agency subject to FOIL is required by law to provide the Committee on Open Government copies of any FOIL appeals they receive and the ensuing determination. So the FOIL appeal and the appeal determination. The Committee on Open Government is supposed to receive a copy of those appeals and appeal determinations. When we received those appeals and appeal determinations, often up until the past several years, it was in paper form. We would review them, look to see if anything stood out that we needed to address with the agency. But then they would just get filed. They would get filed in a filing cabinet based on the date we received them. They weren't logged electronically. We just filed them. And so if someone had come to me and made a Freedom of Information Law requests for copies of all FOIL appeal determinations issued by the New York State Department of Health, we would have had a very difficult time complying with that FOIL request because our records were not maintained in a manner that would allow us to locate the appeal determinations issued by the Department of Health with reasonable effort. The paper copies were filed by the date received. We had no way of knowing which of the thousands of FOIL appeals that we received had been issued by the Department of Health unless we went through each page, appeal determination page by page. And based on very old case law, we didn't have an obligation to do that. We didn't have the obligation to search for the needle in the haystack. Now, within the past couple of years, we started to log the appeals in basically just in a simple Excel database, but we have a record, hopefully, of all appeals and appeal determinations issued by the Department of Health. We know when we received them and we know where they're filed. So that's a situation where it makes it easier when you have electronic records, or at least if you have some sort of electronic filing system, it makes it a little simpler to locate the records that are being sought. So there are certain time limits that come into play when you're dealing with the Freedom of Information Law. Time limits that both to a large extent, the agency is required to comply with, and to some extent, the applicant for records is required to comply with. When an agency receives a FOIL request within the first 5 business days, it's required to do something. It must either provide access to the records sought, deny access to the records sought, state we don't have the records that are being requested, or if it's a larger request or a more complicated request, the agency will be required to acknowledge receipt of the request and state that it needs more time to respond. Under the statute, sort of the rule of thumb is generally an agency should respond no more than 20 business days from the date of the acknowledgement. However, if given certain factors, given the circumstances surrounding the request, an agency requires more than 20 business days to respond to a FOIL request. It can take more than 20 business days, but it is required to give a date certain by which it plans to respond that is reasonable given the circumstances of the request. And the notification to the applicant must provide a reason for the delay. Generally, it's our feeling that agencies should not be engaging in issuing repeated extensions. What's the best thing to do is to evaluate the request either within the first 5 business days, or if necessary, within the first 25 business days, I guess, and see how long is it going to take to respond to this request, and then give a date certain. It's not helpful to the agency and it's not helpful to the applicant if every month the agency is simply issuing another letter saying, we'll get back to you next month, we'll get back to you next month. It's best if the agency can be clear upfront how long it's going to take to respond to the request. So for example, if the agency says this is a very large request and it's going to take us 6 months to gather and review the records, the applicant may say, I didn't really quite realize it was going to take us that long. I'd like to narrow the scope of my request to something much more specific. And then of course that's helpful to the agency and helpful to the applicant. So now the applicant is getting exactly what they want and the agency doesn't have to engage in quite as much work. If there's a denial of access, an applicant has 30 calendar days to appeal that denial. Once the appeal is received by the agency has 10 business days to respond to the appeal. Email requests, if an agency is able, it must accept requests by email. In my opinion, every agency should be able to accept requests by email. I can't imagine that there's any agency that doesn't have that ability at this point. An agency cannot require a requester to use its own form, but it can require that the request be made in writing. That's not to say there's anything wrong with an agency making a form available, a FOIL request form available to its constituents, to the public to use to make FOIL requests. There's absolutely nothing wrong with that whatsoever. I think many people in the public actually appreciate it. However, if an agency receives a FOIL request in writing and it is directed to the records access officer, then the applicant has done their part. An agency cannot bump that back and say, we're not going to respond to your FOIL request until you fill out this form. Once the applicant has made the request in writing, they have done their statutory duty and they cannot be required to fill out a form. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. So if a FOIL request comes in from janedoe@gmail.com and is asking for a copy of a contract, for example, that's a record that would be publicly available to anyone who asked for it. So the agency should simply respond via email if they're able to do so with an electronic copy of the contract, and there should be no concerns about, they should not be requiring that the applicant identify themselves. Appeals. There are two sets of circumstances that give rise to the right to file an administrative appeal. The first is what I call, this is not a statutory term, but I call it an express or an affirmative denial of access. And that's a situation where a record is possessed by an agency, but the agency has determined to withhold it in whole or in part. That would be a denial of access, even if it's a redaction. If you have a 5-page document and 3 words in that 5-page document are redacted, then the agency has an obligation to treat those redactions as a denial of access and issue a determination accordingly. These other situation that gives rise to the right to file an administrative appeal is what we term a constructive denial of access, and that's when an agency fails to respond to a request within the time limit set forth in the statute. So for example, if an applicant submits a FOIL request to an agency and 5 business days comes and goes and the agency hasn't responded, even acknowledged the request, then that could be deemed a constructive denial of access. Or if the agency acknowledges the request and says, we'll get back to you within 20 business days, but the 20 business days comes and goes and there's no response from the agency, again, that would be considered a constructive denial of access, which would give rise to the right to file an administrative appeal to the agency's appeals officer. We have model language for both of those types of appeals on the Committee on Open Government's website if you're looking for sample language. So here is where it becomes helpful to know that copies of these slides are available on our website. So I'll repeat that again for people that may not have been available or that may not have logged on right at the beginning of the program. Copies of these slides are available on the Committee on Open Government's website. On our homepage, we have a section that it links to training material, training recordings and material. You can find copies of these slides on those links. There are several permissible grounds for denial of access to a record or a portion of a record, and excuse me, they're based on the concept that harm would be caused by disclosure. So we'll go through some of the more commonly asserted grounds for denial of access. The first one we'll talk about is where a record or a portion of a record is exempt from disclosure by state or federal statutes. Some examples are records that are covered by the attorney-client privilege under New York State civil practice law and rules. So for example, if you have a town supervisor reaching out to the town attorney and requesting legal advice, and the town attorney writes back providing legal advice, that is an attorney-client communication that is made confidential by New York State's statute, by New York State civil practice law and rules, and is exempt from FOIL disclosure. For school districts, whether it's elementary school, high school, community colleges, CUNY, SUNY, any public education institute, if you make a Freedom of Information Law request for a copy of a particular student's education record, those the school is going to be prohibited from disclosing those records under the Freedom of Information Law. Access to those records is going to be governed by federal statutes, the Family Educational Rights and Privacy Act, or the acronym is FERPA. So those records are exempt from FOIL disclosure by federal statute. I used to be the records access officer for the New York State Office of Mental Health. Sometimes we would receive FOIL requests for psychiatric records. Those records are prohibited from being disclosed under the Freedom of Information Law because they are confidential pursuant both to federal statute, but the federal privacy regulations, but also New York State mental hygiene law. Access to those records is governed by mental hygiene law, and they are not available in response to a FOIL request. Some lesser known confidentiality statutes there's a provision of county law that makes autopsy records confidential. There's a provision of county law that makes county-operated 911 records, including recordings and transcripts of a 911 call. If the 911 call was made to a county-operated 911 program, those are confidential under New York State county law. Social security numbers are confidential pursuant to Public Officers Law, Section 96A. So if a agency receives a Freedom of Information Law request for a record that contains an individual's social security number, that social security number must always be redacted prior to disclosure of the record. Another one of the grounds for denial is when disclosure of a record or a portion of a record would constitute an unwarranted invasion of personal privacy. Some examples here might be the employment application of an individual that was not hired. There was an opening in a government agency, 10 people applied for that opening, only one was hired. Well, the employment applications of the individuals that applied but were not hired could be withheld on personal privacy grounds. Home telephone numbers, personal cell phone numbers of both public employees and citizens where that information has been provided to a government agency could be withheld on personal privacy grounds. Medical information that might be contained in a public employee's personnel file, for example, could be withheld as an unwarranted invasion of personal privacy. There's a provision of FOIL that specifically states that public employees and retirees' home addresses can be withheld on personal privacy grounds. Lists of names and addresses of natural persons if that information is going to be used for solicitation or fundraising purposes. So if a town government maintains a list of the names and addresses of all the individuals to whom dog licenses have been issued, and someone makes a FOIL request for that list, the town clerk could require that the applicant certify that they will not use that information for solicitation or fundraising purposes. So if the person who's making the FOIL request was, for example, a new dog walking company, entity that was looking to reach out and try to make new clients, that person would not be able to complete the certification that they were going to, that they wouldn't use the information for solicitation or fundraising purposes. And if they were not willing to provide the certification, the agency, the town, could deny access on personal privacy grounds. Fairly recent update to the statute is that copies of mugshots or booking photographs is what the statute refers to them as, more commonly known as mugshots. If a FOIL request is made for an individual's mugshot, a local law enforcement agency is permitted to withhold a copy of that mugshot on personal privacy grounds. That doesn't mean that a law enforcement agency can't proactively use mugshots for a legitimate law enforcement purpose. If they need to put out a copy of a mugshot to the media to try to get the public's assistance in locating someone, they're still free to do that. It's just that they have the ability to withhold a copy of a mugshot on personal privacy grounds. And that's something that I need to point out. I'll take this opportunity now to point out, except for the records that, going back to, except for the records that are exempt from disclosure by state or federal statute, the rest of the grounds for denial are all permissive, meaning you're allowed, as a government agency, to withhold records where disclosure would constitute an unwarranted invasion of personal privacy. You're allowed to withhold records which are compiled for law enforcement purposes and where disclosure would cause some type of harm, but you're not required to. You're only required to withhold a particular record if a separate state or federal statute says that the agency must withhold. That separate state or federal statute is going to govern disclosure as opposed to FOIL. The rest of the grounds for denial are all permissive. They allow you to withhold as a government agency, but don't require that the government agency withhold. They don't prohibit disclosure. So we talked about personal privacy. The next ground for denial that we're going to talk a little bit about is where a record is compiled for law enforcement purposes and where disclosure would cause some type of harm. And this is a two-part test, and a government agency has to be able to assert both parts of the test in order to withhold a record or a portion of a record. First is that the record has to be compiled for law enforcement purposes. And based on fairly recent case law, about 5 years, the case law that I'm talking about is from about 5 years ago. The courts have held that in order to determine whether the records were compiled for law enforcement purposes, you're going to look to whether the records have been put together for a law enforcement purpose at the time the request was made. It doesn't really matter, based on this case law, whether the records were originally compiled for law enforcement purposes. It matters whether they've been compiled for law enforcement purposes by the time that a FOIL request has been made for them. The case at issue involved a former employee of the New York State Executive Chamber, and the New York Times made a FOIL request for this person's timesheets. And the executive chamber had compiled those timesheets and handed them over to the to the United States Department of Justice because there was a federal investigation going on. And the court said, yes, even though those timesheets were not originally compiled for a law enforcement purpose, they were created and compiled for the purpose of keeping track of somebody's time and attendance. But by the time the FOIL request was made, the records, the timesheets had been compiled for a law enforcement purpose and turned over to the Department of Justice. And the courts held that that met the definition of compiled for law enforcement purposes. Second point here is that the exemption does not apply solely to records compiled for a criminal law enforcement purpose. It could also be for a civil law enforcement purpose. A case at issue involved the New York State Education Department, and they had civil law enforcement capabilities, and the records at issue had been compiled for a civil law enforcement purpose. That's the first part of the test. The second part of the test is whether disclosure would cause one of the harms envisioned by the statute. And then you need to look to see whether any of the harms that are described in the statute would be caused. One common harm is that disclosure would interfere with a law enforcement investigation or judicial proceeding. If the agency that maintains the records to which the FOIL request was made is not the agency conducting the investigation, the agency that received the FOIL request has an obligation to go to the agency that is conducting the investigation to receive confirmation that disclosure would interfere with the investigation. The second type of harm is where disclosure would deprive a person of a right to a fair trial or impartial adjudication. The third is where disclosure would identify a confidential source or disclose confidential information relating to a criminal investigation, and there it specifically identifies criminal investigations. And the fourth is where disclosure would reveal non-routine criminal investigative techniques or procedures. This is the type of record which may allow somebody who receives the records to evade law enforcement detection. Certainly you don't want to give any potential criminals the combination to the safe. Another ground for denial of access to a record is where the record constitutes either intra-agency or interagency material. This ground for denial is intended to protect the deliberative process. Intra-agency or communications between or among employees or officials of a single agency, and interagency material are communications between or among employees or officials of either two or more government agencies. So for example, if you have a town supervisor email the town clerk, that's going to be intra-agency. If the town supervisor emails me at the Department of State, that's going to be interagency. There are exceptions to the interagency material exception. An agency, even if a communication or a document constitutes interagency material, if that document or record contains statistical or factual tabulations or data, if it contains instructions to staff that affect the public, final agency policies or determinations, or external audits, including audits conducted by the New York State Office of the State Comptroller, those records or portions of records are required to be disclosed. So you would review the document as an agency, determine whether there are portions that must be disclosed, and you could redact the remainder. When a FOIL request is made to an agency and the agency responds that it does not possess the records sought, that's not a denial of access that gives rise to the right to an administrative appeal. It simply is hopefully a statement of fact that the agency does not possess the records sought. And there's a provision of the Freedom of Information Law that states, in part, upon payment of or offer to pay the fee prescribed, the entity the agency shall provide a copy of such record and certify to the correctness of such copy if so requested, or, as the case may be, shall certify that it does not have possession of such record or that such record cannot be found after a diligent search. So when an agency indicates that it does not maintain or cannot locate a record, an applicant for the record may seek a certification to that effect. So if a request for that certification is made to an agency, the agency is required to provide the certification if it's accurate. Sometimes a request for a certification prompts an agency to conduct a second search, which may lead to different results. But if the agency is confident that it has already conducted a diligent search, or if the agency is prompted to conduct a second search and both searches result in no responsive records, if requested, they are required to provide a certification to that effect. When an applicant is denied access to a record or any portion of a record, that applicant has 30 calendar days to appeal that denial. The Freedom of Information Law requires that every agency appoint a FOIL appeals officer who is either the head or governing body of an agency or a person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial. Sometimes it's a combination of both those things. If the FOIL appeals officer agrees in part but disagrees in relation to another part of the determination. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeal level. And as a reminder to anyone who has FOIL responsibilities at a government agency, again, the agency is required to send a copy of the appeal and the appeal determination to our office. The email address I'm going to provide at the end of the program is the perfect email address if you'd like to email it, or you're welcome to mail. So it's not the applicant's responsibility to provide us with a copy of the appeal. That obligation is always going to be on the government agency. They are required to provide us a copy of the appeal and the appeal determination. My experience is that many agencies are pretty good about sending us their appeal determination, but often they forget to send us a copy of the appeal that prompted the appeal determination. So I'll just note that for any government agencies that may be listening in right now. Fees. Fees are always an interesting question. There are two fee structures under the Freedom of Information Law, and these fee structures cannot be combined. It's either one or the other, not both. The first fee structure is for photocopies up to 9 by 14 inches. If you have an applicant that would like a photocopy of a standard 8.5 by 11 piece of paper, you are allowed to charge them 25 cents per photocopy. That's it. End of story. The law does not allow an agency to charge for search time or for the time it takes to review the records to determine rights of access. As a government agency, you're only allowed to charge for the cost of making the copy, the 25 cents per photocopy. The second fee structure is for either photocopies that are larger than 9 by 14 inches, for example, maps or blueprints, or records in some other format other than photocopies. And then what the law states is that you are allowed to charge the actual cost of reproduction for those records. And then the law defines what you are allowed to include to determine the actual cost of reproduction. One of those factors is if it would take, let me back up a little bit. Sorry, my voice is going on me. An agency is allowed to pass along the hourly salary of the lowest paid employee capable of preparing a copy of the record if it takes at least 2 hours to make the copy. So here, for simplicity's sake, let's use scanning as an example. Let's say the applicant says, I see the records that I'm looking for are only in paper format, but instead of making photocopies of those records, I'm going to ask that you scan them and email them to me. if the agency can just as easily scan as they could photocopy the records, and it's going to take at least 2 hours to scan the records, the agency can charge the salary of the lowest paid employee capable of performing the scanning multiplied by the number of hours it takes to perform the scanning. But again, only if it takes 2 hours. If it's only going to take 20 minutes to do the scanning, then no fee can be charged. If a file is too large to be sent via email and needs to be placed on an electronic storage device like a CD, DVD, thumb drive, an agency is permitted to pass along its cost of an electronic storage device. If an agency needs to send a record out to a third-party vendor, for example, maybe it's audio or video or blueprints or maps, something like that, that needs to be sent out to a third-party vendor, the agency can, whatever the third-party vendor charges the agency can pass that cost along to the applicant. But again, the agency cannot charge for search or review time. The only fees that are allowed to be charged by a government agency, the actual cost of making the copy. So if it takes an agency several hours to locate the records prior to making the copies, that's not a reimbursable cost to the agency. If it takes your town attorney 3 hours to review the records to determine rights of access, that is not a reimbursable cost. I was the records access officer for the Office of Mental Health. Oftentimes, I was sitting in my office for hours and hours on end with Sharpie in hand, redacting records. The Office of Mental Health was not allowed to pass along the cost of the time it took me to review and redact those records. It's not a reimbursable cost. Enforcement. The Committee on Open Government is authorized to provide advice and legal opinions regarding the Freedom of Information Law and the Open Meetings Law. We do not have enforcement authority. We don't have the authority to conduct investigations or go on sort of fact-finding missions. We can provide advice and legal opinions regarding the open government statutes. Enforcement of the Freedom of Information Law is through the initiation of a Civil Practice Law and Rules Article 78 proceeding in State Supreme Court. If a petitioner prevails, attorney fees and other reasonable litigation costs can be awarded. Those fees are going to be mandatory on the part of the judge when the petitioner has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. Attorney's fees are going to be discretionary when requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. So finally, as promised, I will remind everyone on the program today that anyone is welcome to contact our office by phone or by email with questions, whether you're a government employee, member of the public, media representatives, etc. All are welcome to contact our office. You can ask to speak with any of the attorneys in our office with your questions. It does not need to be me. Our phone number is up on the screen right now. It's 518-474-2518 is our office telephone number. And our general email address, which will reach all of the attorneys in our office, is the acronym COOG, C-O-O-G, @dos.ny.gov. All right, so I'm just going to go back to, I'm going to go look in the chat box. Hold on just a moment. Stop sharing. And see if we have questions that were not addressed during the program. Someone asked what I meant by natural persons when I talked about unwarranted invasion of personal privacy, the lists of names and addresses of natural persons if the information would be used for solicitation or fundraising purpose. What I mean here is that it's not people acting in their business capacity, it's not corporations, it's residents, for example, the example that I gave about people that had been issued dog licenses. You live in a town, you go and you pay your fee and you get a dog license, and the town clerk has your name and address. That would be natural persons. On the other hand, many agencies receive FOIL requests for information about their vendors, and vendors are not natural persons. An individual, a commercial entity is not a natural person. A person acting in their business capacity would not constitute a natural person. And the reason why it's limited, why we use that term natural person, is because we're talking about personal privacy. So a company does not have personal privacy. An individual acting in their business capacity doesn't have personal privacy relating to their business when they're doing business with a government agency. So that's the distinction there. Someone asked, can an agency require that you provide your name, address, reason for requesting the records, etc.? So that's a good question. The answer is no, except in that very limited circumstance where you may be where you might be asking for the names and addresses of natural persons. In that case, an agency can require a certification that would include your name and address, and a certification that you're not using the information for solicitation or fundraising purposes. The only other exceptions is if you're asking for records that may involve personal privacy issues. So for example, if someone goes and makes a FOIL request for a law enforcement incident report, and there are aspects of that incident report where the law enforcement agency would not disclose to the general public, but would disclose to the subject of the incident report. If you want an unredacted version of the incident report, the agency is going to be permitted to require that you provide proof of your identity. But if you are making a request for a record that would be publicly available to anyone, no, you have the right to make a request anonymously, and the agency should not be requiring that you provide your name, address, or a reason for the request. Another question is, are you required to notify a requester of the cost of copying records prior to completing the request? Or can you complete the request, then notify, then notify the requester the cost? Is another excellent question. The law distinguishes between photocopies and everything else. The law states that you are required to notify the requester of the cost of copying when it is anything but photocopies. My personal recommendation is to always notify the requester of the cost of copying before you incur the cost on behalf of your agency. Particularly if it's any large number of records. I mean, you don't want to spend use up all paper and ink and then find out from the person who made the request, oh, I didn't realize that it was such a voluminous set of records. I'm not really willing to pay $50 for the cost of these records. My recommendation is to always let them know how much it's going to cost prior to making the copies, but the law specifically states that an agency must notify the applicant when when you're making copies in a format other than photocopies up to 9 by 14 inches. Let's see. With respect to person acting in their business capacity, I don't understand this question. So someone says, with respect to person acting in their business capacity, where do we draw the line? Do we treat the privacy of a vendor's janitor as we would the vendor's CEO? I guess I don't really understand the question. If the person who asked the question wants to follow up, I don't understand the question, I guess is what it comes down to. Again, individuals have privacy, but a person acting in their business capacity, let's say, for example, you own a contractor, you're a contractor and it's your business and you're doing business with a municipality. You, in your role as a contractor doing business with the municipality, has less of an expectation of privacy than if you were a resident who is contacting your municipality with questions about services. There's that distinction there. There's a difference between somebody acting in a business capacity than there is someone who's acting in their personal capacity. And that's where personal privacy comes into play. If the person that's asking this question and has like to follow up with me personally, they're welcome to do so. We don't have a lot of questions today, so if anyone does want to add to the chat in the next like 30 seconds, that's fine. I'll remind everybody once more that a recording of this program will be posted hopefully by the end of this week on our website. Copies of the slides will be available on our website, so I do ask that you not reach out to me by email and ask for copies of the recordings or copies of the slides because I won't be able to respond to everybody. Please go to the website to get that information. Still no follow-up emails, so I want to thank everybody for joining me this morning. And if anyone really wants to punish themselves, I'm doing a program on the open meetings law this afternoon at 2 o'clock. And there's registration information on our website regarding that program as well. Thank you, everybody. Have a good day.